I am Joe Brigham, Senior Counsel and Natural Resources Practice Leader at Mountain States Legal Foundation. You can check out our website at mslegal.org. I'm here with Will Yateman, who is at the Cato Institute, where he works on administrative and constitutional law issues, especially environmental issues. Mountain States and Cato filed a joint amicus brief in West Virginia versus EPA, which is a decision that just came down from the Supreme Court today. So I'm going to start off with kind of framing the issue with some very basic background. And that's the concept of non-delegation. So the EPA took some major actions here that are at issue in this case and that we'll get into more detail about in a minute. And the question before the court is whether the EPA had the statutory authority to do that. The EPA is an agency in the executive branch, which was created by Congress and derives its authority from the statutes put in place by Congress that authorized whatever the EPA can lawfully do. The idea of non-delegation comes from the fact that the Constitution says we have three branches of government: the legislative, the executive, and the judicial. And almost all of us, I think, would agree that if Congress passed a statute that says this Congress hereby delegates its authority to the President of the United States, that statute would be constitutionally void because Congress cannot disband itself and grant its authority to the president. It's the legislative power that the Constitution vests in Congress can't be removed from Congress without a constitutional amendment. So that idea is the non-delegation doctrine, that that Congress can't delegate the legislative authority that's given to it by the Constitution to the president. And we all agree that there's some limit to what Congress can delegate to the president. It can't be the case that Congress cannot delegate any decision-making authority to the executive branch. Because even if the executive branch was solely concerned with, say, criminal law enforcement, it has to be able to make decisions about how it enforces those laws. And so what we're talking about in this case is where to draw the line. How do you determine when Congress has delegated so much discretion to the executive branch that it amounts to an abdication or delegation of the legislative power that can exist only in Congress? So what's not at issue in this case is the extent of the federal government's power to do what the EPA did. The federal government, for purposes of this case, we can assume that the federal government did have the power to do everything the EPA did. The question is allocation of federal power. Does that power reside with Congress or with the president? And so I'm going to turn it over to Will. Can we still hear you, Will? I think you're muted.
I can hear you loud and clear. Can you hear me?
Great. I can hear you and see you.
All right. I'm sorry for this goofy setup, but
that's all right. So I wondered if you could introduce the major questions doctrine, which is kind of a subcategory of the non-delegation doctrine, although that's roughly true, I guess, and explain what the EPA did here and how the major questions doctrine applies to it.
You bet. So with respect to the major questions doctrine, I think you've set forth in this context of the non-delegation doctrine, I think you did a good job setting the table. It can be thought of as sort of an as-applied non-delegation challenge. And so what is it? It basically means the court is suspicious of agencies justifying major regulations on the basis of expansive interpretations of vague old laws. And it's an idea that's been bouncing around the Supreme Court in a handful of decisions over the last 25 odd years. The court, it never actually used the words major questions doctrine, but again, it was alluding to this sort of presumption against agencies basing big policies on ambiguous texts. There was a clear line through these cases, if you will. And as we'll get to, what Chief Justice Roberts did in West Virginia v. EPA was flesh out the doctrine. And in particular, he answered that $64,000 question that is really been at the center, or has been crucial, I guess, to the criticisms of the major questions doctrine and its development, and that is how you identify a major question. But before we get there, so what are the underlying facts of this case? Well, I guess we'll have to go back to the 111th Congress. So in 2009, the House of Representatives passed a cap and trade, the American Clean Energy and Security Act. The bill ultimately died on the vine in the Senate. They couldn't even get it out of the Democrat caucus. So Obama wins re-election 2012. So one of the first things he does thereafter at Georgetown University at a big speech, he orders the EPA to work on a major climate policy. A couple years down the road, 2015, EPA comes out with the Clean Power Plan that, at the end of the day, is a federally operated nationwide cap and trade, the exact sort of policy that the 111th Congress had deliberated on and ultimately demurred on. So we setting aside, I guess, this is a legally oriented crowd. In an unprecedented move, the Supreme Court, and this was pre-Trump, stayed the Obama administration's Clean Power Plan. This is way back in late 2016, right before Scalia passed. So that's a little bit of a legal context, to this controversy. So the Trump administration, the Clean Power Plan has stayed. What does the Trump administration do? Well, it's presidential administration, if you will. That is to say, it's going to reverse everything the prior guy did. So Trump rescinds the Clean Power Plan. The justification for the rescission was basically that the statute unambiguously forecloses the EPA from imposing a nationwide cap and trade under Section 111D. At the same time, the Trump administration issues its own rule, the American Clean Energy Act, the Affordable Clean Energy Act, Affordable Clean Energy Rule. It doesn't matter. The point is, Trump rescinds it and puts in place his own rule. That rule is litigated by the environmental interests. Is litigated out the wazoo. That was a long-winded, way of getting to the controversy before the Supreme Court. But it is sort of a complicated backstory. But the long and short of it is, it gets before the CADC, the D.C. Circuit. That is the Trump administration rescission of this Obama-era rule. And the D.C. Circuit, it could have dismissed the Trump-era rescission and the Trump-era rule on arbitrary and capricious grounds. It could have dismissed it using a statutory argument that really would have been innocuous, that would have left the initiative on climate policy to the Biden administration. But that's not what it did. The CADC went out of its way to not just condone the legal reasoning behind Obama's Clean Power Plan, which again was only indirectly before the court by virtue of the Trump administration's rescission. The court didn't just go out of its way to expressly condone that legal reasoning. It suggested that an EPA-administered cap and trade or some sort of EPA-administered policy to achieve quote-unquote generation shifting was mandated by the Clean Air Act. And that was a pretty big deal. But it was, I would argue, in large part because the CADC went out of its way to really, I guess, what it thought it was doing to set the table for the Biden administration, that it incurred the Supreme Court's interest and ultimately the decision that we got today. So the D.C. Circuit said not only does the EPA have the power to implement the Clean Power Plan, but it is required by statute to implement something like the Clean Power Plan. They didn't come right out and say it, but they hinted strongly that something major was demanded by the statute to take on the major problem that is global climate change. So that was, it was more they were hinting at it. It was they're going out of the way to expressly condone the legality of the Clean Power Plan, and it's that is the legal basis in 111D for generation shifting. That was what they did. I guess the unnecessary, superfluous, if you will, to use a textual term. They're going out of the way for that in particular was, I believe, what. It incurred the court's interest. They didn't have to do that, and ultimately, that's the whole reason that this thing came before the Supreme Court.
So when it gets before the Supreme Court, there are a lot of kind of nitty procedural issues. I'm afraid we lost people a little in the weeds with the complicated posture of the case that involves a couple different rules being challenged. But the upshot is that ultimately Obama's Clean Power Plan ended up before the Supreme Court for the Supreme Court to decide whether the EPA had authority under its under the Clean Air Act to implement the Clean Power Plan.
Indeed, like that was. I do apologize for the fact is that the complicated backstory is an important component of the case, but that was a long-winded explanation. But you're exactly right. The nuts and bolts of it is the question before the court is whether or not this Obama-era policy was indeed a major question, and if so, whether or not agencies have the authority to promulgate such a major policy on the basis of a quote-unquote ancillary provision of the Clean Air Act.
So once it got to the Supreme Court, we, Cato and Mountain States, filed a brief arguing that some version of the major questions doctrine should apply in this case, and then trying to answer the question that position immediately raises, which is how do you know when the major questions doctrine applies to something? And I will confess that I've always kind of hated non-delegation, even though it's obviously a true principle. It's I like rules and not balancing tests, and so it's really hard to come up with a straightforward formula for determining whether Congress has delegated too much power to an agency, or whether an agency has the authority to determine that Congress has delegated the power to do something. And one reason that I liked our brief, which you were the primary author on, I think, is that it proposes a framework to identify major rules, which would be, first, is the agency filling in the details or is it answering major questions? Second, is the agency action historic, kind of groundbreaking? And finally, did Congress try to do what the agency is doing and not do it? And so even though that is still kind of a balancing test, which I don't like, it at least goes a long way toward fleshing out a system to apply to a proposed agency action or interpretation of a statute that's better than just, Congress can't delegate legislative authority. And so can you get us into what the decision today did, what the outcome was of the case? I mean, the big picture outcome is the Supreme Court said that the EPA does not have the authority to implement the Clean Power Plan. But how did it get there?
Well, you bet. So the crux of the court's reasoning, or of CJR's reasoning in particular, was the development and, I guess, firm establishment of this major questions doctrine. That is, it found that the Clean Power Plan was indeed a major policy, and that it was indeed or of the sort that requires a clear congressional statement. So, I'm sorry. the dissent, when it says the court announces, it announces the coming of or some such of the major questions doctrine, that's in part right. The fact is that for 25 years, this thing has existed only in passing. Only by side reference. I guess Kagan is part right and part wrong. This thing has been mountains of papers have been written by academics. So the major question.
Kagan, sorry to interrupt, but for the lay people, Justice Kagan is the smartest of the court's left wing, and she authored the dissent in this case for the three liberal justices, saying that the EPA should have was correct to interpret the Clean Air Act and give it this authority.
Indeed. And I guess one of our most striking statements that has made the rounds on social media is that the majority came up with this out of thin air. And that's, really not the case. Again, the seeds of this doctrine had existed for 25 years. What Roberts did is he put it all together into a cogent, applicable framework that will actually work in practice. And he pointed to a number of factors, a number of indicia that will be tells, if you will, for a lower court that they're dealing with a major question. And as it so happens, as Joe set forth, they happen to track, the framework that we had pitched. Again, the whole purpose of our brief was we had asked the court to please flesh out this major questions doctrine, that lower courts are confused as to what actually is a major question. And to that end, we pitched a few factors, and ultimately, Chief Justice Roberts, be it coincidental or be it that we were influential, he used them. And so what goes into a major policy? Well, is it unprecedented? Is it something historic that the agency has never tried before? Roberts identified that. Again, is it something a policy that Congress has already deliberated on and passed on? And that's certainly happened here. Is it outside the agency's expertise? This is one we didn't actually address in our merits brief, but we did address in our cert stage brief. The EPA in 2015 had gone to Congress and had asked for funding for energy experts. And its experts, when it sought to justify this request, it said, hey, we're going to try to regulate the entire grid. And this is outside of our traditional areas of expertise. Roberts pointed to that and said, when an agency concedes it's operating outside of its normal area of expertise, then, that's something we should be wary of.
Takes away one of the stronger arguments for congressional delegation to agencies, because part of the reason that we let Congress delegate some things to the executive branch is that the executive branch employs people with the relevant expertise.
Exactly. Look, that's the sine qua non of the administrative state, that and efficiency. So yes, that the EPA would concede via these budget documents that it's operating outside of its wheelhouse. That's a red flag. The other factor that you mentioned was the nature of the question presented. Is it interstitial? Is it the agency filling in the details, or is the agency trying to implement a big and bold policy? Obviously, a nationwide cap and trade is the latter. So you take all these factors together, and you've got a really limited subset of the administrative state or of the regulatory output of the administrative state. That is to say, you'll hear some on social media and no doubt in the newspapers tomorrow, or I guess online right now, progressives talking about how this is going to take a wrecking ball to the administrative state. But that's simply not true. By clarifying the doctrine, Chief Justice Roberts, to say by clarifying the major questions doctrine, Chief Justice Roberts is really limiting the set of regulations that before today would have applied. It's basically the president's tried this sort of stuff only a handful of times per term, every 4 years. And in the future, I expect they won't do so. This will be a deterrent to such sort of interpretive adventurism inherent to this presidential administration.
I'm sorry to interrupt. We're starting to run out of time, I guess I'm hearing. So can you tell me maybe the top three examples of other areas where you could see the newly fleshed out major questions doctrine being applied. I mean, I tend to think that this would have fairly narrow application because there are very few agency actions that are kind of this egregious in terms of agencies expansively interpreting their own authority. But then, a lot of people are saying that this is kind of the end of the administrative state and we're all going to die. So where else do you think this might be applied besides the EPA regulating the nation's electric grid?
Well, I guess it flew under the radar, the reasoning, but it applied twice in the last year to two COVID measures, the eviction moratorium and the vaccine mandate. I mean, the court rolled out this doctrine twice, or again, it sort of alluded to these principles without fleshing out the framework. But that said, I agree with you 100%. It's not that common that agencies are rolling out regulations that check all these boxes. I mean, that they're unusually costly, that they're unprecedented, that they reflect failed legislation, that they're outside of the agency's expertise. Or other, I guess, pending examples, certainly the SEC's climate rule. I mean, that's seemingly outside their area of expertise. It's a huge measure. It's unprecedented. If the FCC is working on a net neutrality rule, that potentially fits the bill just because, again, Congress has tried and failed at that a number of times. But I think the biggest effect will be as a deterrent. I mean, these rulemakings for major policies, they're resource intensive. And this is a pretty clear signal from the court that this sort of interpretive adventurism, which again is part and parcel of this phenomenon known as presidential administration, where the president is the one calling all the shots in domestic policy making. But I don't think we're going to see as much of it, and I think that's a very good result, and it's going to lead to, let me make this one point, it's great for legal stability. I mean, the problem with presidential administration is ping pong, back and forth the policy goes between a Republican and a Democrat. We saw it with this climate policy. I mean, Obama did one thing, it was undone by Trump, and then Biden was getting ready to redo it. And that's, the electricity grid's a pretty important sector to be subject to sort of this spin cycle of uncertainty. That's a pretty darn big benefit, legal stability to our administrative law.
Yeah, and I guess I would say that's a big benefit. I think the ideal outcome here would be that that agencies that want to do something big go to Congress and say, tell us to do this, or give us the authority to do this. And it will encourage Congress to kind of return to doing its job of legislating.
Hear.
So in closing, I just want to reiterate what's not at issue in this case and what is at issue. What's not at issue is the federal government's authority to do what the EPA proposed here, or so that authority, we assume for purposes of this case, it exists. And it's not even just that authority only resides with Congress, because Congress could respond to this decision by authorizing the EPA to do what it proposed to do here. It's not even that this agency action is inherently non-delegable by Congress. The problem is that Congress didn't delegate it, and that if an agency is going to do something huge and unprecedented that amounts to a major question, then at the very least, Congress should have said that the agency could or should do that. So we have not only non-delegation issues, but just an issue of kind of how much democracy is a good thing. And there are strong arguments against democracy, and Justice Kagan makes them. But there are also, downsides to concentrating power in the hands of the executive. So anyway, we need to wrap up, but thank you, Will, for doing this brief with us and for joining us today and helping explain the court's decision. And thanks to everybody who tuned in or is watching this after the fact. Please check out Cato and Mountain States Legal Foundation's website and look for ways to support the liberty movement. Thanks again, Will.
Thank you.
Bye.